What's up, everybody? In tonight's video, we're going to be breaking down comments made by jurors in Nikolai Mew's trial, the Apple River trial, where he was convicted of first-degree reckless homicide. And we're going to look at what they focused on. What was the first thing they needed to decide in that jury room? What was the vote like in the beginning of the case? And were more jurors actually leaning for a harsher charge or a lesser charge? It's a short video, but it packs a lot of punch. There's a lot to be learned and compared to what our chat and our community was talking about during this trial. And you're going to be interested to hear the similarities and differences with this jury and our votes and our community here and what they discussed as being so important in this trial. So make sure you guys hit that like button and subscribe to our page because we're going to jump right into this video. All right, so we're going to see what these jurors had to say. It's comments from multiple jurors, and it's in kind of interview fashion over the phone, so we're not going to see the jurors, which is fine. However the jurors want to do it is the way we should do it in this game, and we should listen to them and the way they want to talk and not force anything, not press anything, not put any of their business out there that they don't want out there. But what they agree to, we're going to listen to, we're going to watch because we can learn. We can learn a lot about our system by seeing what do the jurors focus on? What can we make better about the process? What did they maybe misunderstand? What did they understand appropriately? What should they understand in applying the law to these facts? Because again, there's no workbook on how to do this before you do it. You just have to deal with the jury instructions and what the lawyers and judge tell you the day of trial, week of trial, whenever you are there serving your civic duty. So here we go. Let's jump into it. Also, they're going to talk about sentencing. There is a sentencing date. We can watch that together if you guys want to. Let me know in the comments if you want to follow sentencing. It could do a number of things in sentencing. I expect he's going to get something equivalent to life in prison for someone at his age and obviously with his health, as he brought up during the trial. But it still may be interesting to watch what the victim impact statements say and what the judge says about it. It's always interesting to hear after the judge sits through an entire trial like this, especially where the room seemed to be a little bit split, at least in our community and our votes. So I think it'll be interesting to discuss and look at how the judge saw the case. So if you guys want that, let me know in the comments.
An update tonight on the Apple River stabbing trial. Nikolai Mew will be sentenced on July 31st for the stabbing death of Isaac Schumann and injuring 4 others. The court announcing the sentencing date earlier today, less than a week after Mew was convicted of first-degree reckless homicide. He was also convicted on charges for injuring A.J. Martin, Dante Carlson, Anthony Carlson, and Riley Madison. They all testified against Mew at the trial. It took a jury fewer than 7 hours of deliberation to find him guilty. Now, for the first time since the trial, we are learning more about how the jury reached its verdict.
Fox 9's Paul Bloom talked to 2 jurors who explained why they did not believe this was self-defense.
I was fearing for my life.
In many ways, Nikolai Mew's trial came down to witness credibility. What the hell is this guy's problem, bro? And the nearly 3.5-minute cell phone video of the escalating encounter.
If there was no video, how hard would that have made your job? What would that case have looked like?
It would have made the jury.
So we all know the video was a big deal, but what did the jurors think? Did they need the video? Was it necessary to help them make their decision? And he said it would have made the jurors' job very hard. Okay, some of what they say is hard to hear, but that's why we have the captions up here on the screen. And, they captioned it out for us as well. So we're going to break down what they talk about, but obviously the video was important. No surprise there. And again, exactly what our chat and everybody that came into our videos thought the same thing.
Jurors' hard job, very hard. I'm so thankful that we had a video to kind of base our thoughts on it.
Fox 9,
Especially if there's disagreements within the jury room, right? And you can go back and point to the video and make your points based on the video, because what the defense attorney said, what the prosecutor said, what this witness said, what the defendant said, everybody can kind of perceive that differently and say, well, I don't remember him saying that, or did he really say that, or did they say this happened first, or whatever it may be. But when you have the video and you're making your arguments with other jurors and you're discussing things back there and trying to battle it out to see what is the right verdict in this case, it's got to be extremely helpful for them to go point to a video, which both sides agree was the true and accurate picture of the events that day. Neither argued it was doctored or cut off too soon. Now, obviously, the Madison Cohen altercation, physical punch, slap, whatever it was not caught on video. So that was probably harder to get an answer to. But what was on video, at least they all knew we can start that we all agree that what happened on this video is accurate.
spoke to a pair of jurors after the panel of 12, 6 men and 6 women, found Mew guilty on half a dozen charges, including first-degree reckless homicide.
So this is the male juror in his 30s. Okay. So on the younger side of the jury pool that we were looking at, right? People in their 70s and up to their 90s potentially. I don't know if they ended up being alternates or what, but that's who we're talking to here. Is male juror, 30 years old, which I think is important. And he starts with, I feel that justice was served.
Feel that justice was served.
The jurors asked us to conceal their identities, wishing to remain anonymous while taking us inside the deliberation process. I spoke to one over the phone who concluded Miyu could have avoided the whole thing.
I mean, it's not like anybody was had a fence behind him or were holding him there. He could have went, even if it was the wrong direction, he could have walked away.
So no duty to retreat. I'm going to back it up so we can
Or were holding him there. He could have.
so we can leave this on the screen, this quote from this juror. So no duty to retreat, which was very important, but you could still consider whether or not it was easy for him to retreat, and he should have, and he could have avoided the whole thing if he would have just retreated. So these legalese and how these laws and statutes are written, and when duties are refused, and it's like burden shifting and what you have to prove and they have to disprove, and no stand your ground, but he's technically allowed to stand his ground, obviously, and defend himself. How the jury perceives that is very important. And when it came to duty to retreat, there is no duty to retreat in Wisconsin. However, his quote is, it's not like there was a fence around him. Even if it was the wrong direction, he could have just walked away. And you know who else was saying that loud and clear? Were the people in our chat. Now, we were kind of split. It was almost like 50-50 guilty, not guilty. And this is probably one of the ones that we weren't overwhelmingly, voting in favor of exactly what the jury did, which makes it an interesting case to me because I respect your guys' opinion as potential jurors in the jurisdiction in which you live. And this one was very split. But the people that thought he was guilty, this was a huge point to them. He could have walked away and he didn't. It was an incredibly important fact. And you guys continued to point it out. You guys continued to have a problem with that. Sounds like this jury did too.
Went, even if it was the wrong direction, he could have walked away.
Actually felt like we put on a good defense. But in many ways, self-defense is a community standard, and it's very dependent upon which group of 12 people within the community you ask.
And this jury thought he should have just walked away. And again, or he could have just walked right past everybody and went back to his group. So again, all of the things, the little things, same thing in Crumbly that I think the jury really held on to is all the little things that they could have done to prevent this. And they look at Nikolai Mew and they're like, all the little things he could have done to prevent this. Now, if it would have stopped there, I think the defense could have a good gripe that, well, it's still, he doesn't have to, so it still could have been self-defense if they all jumped him and he responded because he had to happen to have a knife on him. So they didn't even answer the question of was he really in fear for his life? But wait, there's more coming.
Walked right past everybody and went back to his group.
Both jurors reasoned if Miyu threw the first punch, as several witnesses testified, he could not then claim self-defense.
You went to Mr. Mew, correct?
Yeah, I went to the guy who was punching people first.
Correct. Again, based upon your memory that he pulled someone's hair and punched them from behind, correct?
Based on the memory that I know that he punched someone, yes,
Okay.
it doesn't
Again,
matter.
not great testimony. Because the defense is even like, based on your inaccurate representation and explanation of the punch, that's what you're basing all this off of. And he's like, well, I know, based on the fact that I knew he punched him. That's not great testimony, but did it matter?
Or how he punched them, I know he punched them, and he shouldn't have.
Prosecutors included a charge of battery, arguing Miyu struck Madison Cohen first, sparking the physical altercation.
Really smart charge by the prosecution, which we talked about before, because, this is something that I really focused on. Again, you guys were spot on with that retreat. I was thinking it doesn't really matter if he could have or should have retreated. If they jumped him, he still has a right to self-defense. So did they jump him or did he start it? And this was the breaking point and the pinnacle and the fork in the road that they had to decide. Did he batter? Did he touch Madison Cohen in an unwanted way? Did he throw the first punch? Because then everything changes. And now he's potentially the initial aggressor. Well, here's how the jury looked at that.
Why was it important to start your kind of deliberations or conversations around the battery?
The Madison Cohen battery charge was a really big thing for the whole case.
I am really glad that this juror said that because I completely agree with him legally speaking. Now, people can see the facts different. You can say, oh, I didn't believe the prosecution witnesses, I believed the defendant, or vice versa. And that's fine. And the jury may see it different from you. They may see it different from me. That's a factual perception that they have to make a call about witness credibility. But what they can't do is say, it doesn't matter who started it. Because Nikolai Mew had a knife, he's guilty. That would be legally wrong and legally insufficient, in my opinion. And I have a problem with that. But the fact that they started with, they had to figure out who threw the first punch, who battered who between Madison Cohen and Nikolai Mew. And they obviously fell on the side that Nikolai Mew battered Madison Cohen. And that is the correct analysis to start this process. And not just say we felt really bad because the kids were young. That's not the appropriate way to do this. Or because someone lost their life or the scars were really, scary and ugly and I wish they didn't happen. That's not the right analysis.
The Madison Cohen battery charge was a really big thing for the whole case because what that basically amounted to is, who threw the first punch? We had more people that said that he punched her.
Well, there was little.
So that's a tough one. Who threw the first punch? Let's see if I can get there. I'm going to put that quote back up on the screen. We had more people say that he punched her. Now listen, if that's how they make the determination, they're allowed to do that. That's legally allowed and legally okay for a jury to say, more witnesses is better than less. I think that's logical. But oh boy, is that frustrating to hear. So an 11-on-1 fight, let's just say, take this case out of your mind. And let's just say it's you and 11 people jump you, but 11 people say you threw the first punch at them. How do you get around this argument? Because more people aren't always right. And that is a tough one for me, right? So no matter how good or bad or, forgettable the testimony was, if it's just more people and more witnesses, this is a criminal defense attorneys and criminal defendants nightmare. Because in the vast majority of cases, I'd say 99% of criminal trials, the prosecutor always has more witnesses. They always have more evidence. They always have more days that they're presenting evidence. And we always fear on the criminal defense side that that's going to be enough to carry the day. They're going to say, oh, they had more witnesses. So we think about it in civil trials too, that, one side's going to call more witnesses just to make it seem like, well, we have more evidence than them, so we must be right, especially with a 51% burden. That's why in some civil cases, witnesses are limited to one per specialty area or 2 or 3 before and after witnesses. So you don't just run in witness after witness after witness to say the same thing, because just because more witnesses say the same thing doesn't mean it's right necessarily. Obviously, if you have more eyewitnesses, that's really important and that can be a factor. But I'll just tell you, the defense attorneys are going to hang their head when they hear this, because it's tough to hear that just because more people said it, that's one of the reasons. And I'm not saying that's the only reason. Obviously, I assume they found those witnesses more credible than Mr. Mew and his witnesses. Obviously, I don't know if they say it in the rest of the interview, but I would bet that there were more witnesses that they also found were more credible.
People that said that he punched her.
While there was little support in the room for Mew's claim of self-defense, I am told that 2 or 3 jurors pushed for a conviction on the intentional homicide charges.
So that was a surprise to me. The jurors tell them that nobody was really pushing for self-defense, which I think we knew. And I think I said during the verdict, it was so quick. I think it was like 7 hours. So it was so quick. I don't think a lot of people were pushing for self-defense, but there were a few people pushing for the intentional homicide, the highest charge, that he went there intending to do this, which, I mean, to me is wild how you get there. But it makes me think a lot of the jurors just bought the prosecution's case, felt bad for the victims, wanted to give justice to the ultimate and highest level, and they were like, let's hammer this guy. But a couple of the other jurors were probably thinking, maybe it should be second degree, or maybe it should be less, and they kind of settled in the middle, and it probably sounds like somewhat of a compromised verdict. And I don't say that as a dirty word. Lots of verdicts are compromised, and I understand we want unanimity. And sometimes when you have to get unanimity, meaning everybody to agree, you got to give and take a little bit. Not everybody's going to see things exactly the same way. So it doesn't bother me that sometimes they land in the middle.
But after looking at everything overall, I think it was just more of a freak thing. It was people in the moment. I don't think initially he had the thought of, I'm going to kill one of these boys or all these boys.
By the way, that quote as well tells you something the prosecution did right and did well in the case. I think there were 2 ways to look at these victims. As grown men, physically able to fight, hurt people, put people in fear, or to look at them as boys. Younger, not as big as Mr. Mew, not as threatening, kids being kids, yelling stuff. And I think the jury picked up that they were boys, kids being kids, just dumb kids. They weren't really there to hurt anybody. And I think that theme was taken by the prosecution, and I think the jury rolled with that theme, that they were just some boys, some kids.
He had the thought of, I'm going to kill one of these boys or all these boys.
Do you think he hurt or helped his case by going on the stand?
Always a question people have, right? Did he hurt or help himself going on the stand? Well, here we get our answers from the juror's perspective.
I don't think he had much choice but to go on the stand. I think if he really was going to plead self-defense and have a case, I think he needed to take the stand to explain himself.
So if he was really going to plead self-defense and have a case,
I think
he needed to take the stand to explain himself. So this is another one that is a little, makes you cringe as a defense attorney, because that's why we say all the time, like, you're not going to hold it against the defendant if he doesn't take the stand. But a lot of you guys, and again, I love that you guys are open and honest about this, because this is how we learn. And so often you are thinking exactly like the jury, and you're all thinking, how does he do this without self-defense? I mean, how does he do this without testifying? He has to testify. And I think this jury was thinking the same thing, regardless of what they said in jury selection. Once this case started to unfold, they're looking over at the defendant like, you don't have a choice, bud. You've got to testify. What does that mean? You don't have a choice, meaning they're going to convict him. Now, it's a lot more fair during the trial after they've already heard all the state's evidence and they're thinking he's guilty. They give him the opportunity to prove he's not, kind of. We hate that verbiage, but that's kind of what it feels like. And I don't hold that against them, because it sounds like he's saying the state proved their case. Obviously, they voted guilty. And so they said it was kind of a Hail Mary, and it didn't work, obviously, him testifying. But does he think he helped the case or hurt the case testifying? Let me know in the comments what you think the answer is going to be. So he said he didn't have a choice. Did he help himself or hurt himself?
needed to take the stand to explain himself.
I lied about the knife.
Was that your knife?
Yes, it is. It was.
In this case, which I think is probably with a lot of cases,
In this case, which I think is probably with a lot of cases, it actually hurt him. So in this juror's mind, he's thinking he has no choice. He has to testify. And in most cases, it hurts the defendant when they testify. That's interesting. Bringing a little experience, like he's obviously got some idea of other cases or how this works in other cases, right? With criminal defendants testifying, and that it doesn't usually go well for them. I don't necessarily disagree with him. Most trials, defendants lose. So obviously most trials defendants testify in, they lose, because most criminal prosecutions, the prosecutor wins. They have all the resources and all the cards and make the decision of whether they want to bring these cases to trial or file these charges. They know what the evidence is before the defense does. So it makes sense that most of the time they win. But it's just interesting with that mindset, thinking he's got to testify, but also, and most of the times, it hurts him to testify.
it hurt him. Just like I was saying, because the stories did not match. There were so many things that were not true that he said.
And also, because he testified in this case, and again, the analysis was very similar to what I said on this channel and what a lot of you guys said. He kind of has to explain himself, but there's no way to get around all the lies he told in that interview right after the stabbing. And, you know, my opinion, the biggest factors were going to be his lies and what he did after. I haven't heard him talk at all about what he did after, so maybe it wasn't a big deal to them. Maybe I was way off on that. To them, it seemed like the lies, the amount of witnesses the prosecutors had saying, you know, the same thing, and that he could have and should have left. But there's no doubt his lies came back to haunt him. The defendant's own words were the best evidence against him and the best evidence the state had to convict him, which is so often true when defendants make statements, especially that aren't true.
As to count one of the information, Isaac Schumann, the jury finds Nikolai Mew guilty of first-degree reckless homicide as submitted.
In the end, it took jurors less than 7 hours to wade through 8 days of testimony, nearly 50 witnesses, and some 30 pages of jury instructions to reach those unanimous verdicts convicting Mew. The now 54-year-old remains jailed in Hudson, Wisconsin, where the district attorney says he is facing up to 97 years in prison when he is sentenced at the end of July, a decision ultimately up to the trial judge, Paul Blinn.
All right. So he's going to be sentenced at the end of July. Again, in the comments, let me know if you want to cover that and you want to talk about that together. But I found this to be so interesting. It's one of my favorite parts about covering these trials is when jurors speak, we learn so much. Did they see it the same way as us? And I would say they saw it the exact same way as about half the channel that was voting for guilty. But more importantly, they saw it exactly like I think all of our channel saw it, which what were going to be the important factors. Duty to retreat, the victim's testimony, how sad it was, his lies, and then obviously we all thought his actions afterwards. Maybe it did, maybe it didn't. It wasn't mentioned in that interview, but I always think it's so cool to get inside a juror's head. I appreciate them commenting. I don't think there's anything here that's going to bring up some major appellate issue or anything like that based on these jurors' comments. To me, it seems like they did their duty. They took it seriously. Whether you agree with the verdict or not, I think they did the best they could. And they believe justice was served. So I find that really interesting. I hope you guys did too. Make sure you hit that like button if you haven't already and subscribe to our page. And let me know what's next for all the Nikolai Mew, the Apple River trial watchers. What are you watching next? Because I'd love to jump on it. I'd love to discuss it with you. I really enjoyed discussing this case with you. I feel like I learned a lot. Hopefully you learned a lot. But until next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.